This week in U.S. immigration news, we are going to cover healthcare proposal for DACA recipients, alert, court hearing date concern, CSPA calculation update. Biden administration on Thursday rolled out a plan to expand health care access for beneficiaries of deferred action for childhood arrivals. Under the plan, DACA recipients will become eligible to apply for Medicaid and to enroll in Affordable Care Act insurance exchanges. DACA beneficiaries are not currently eligible for those benefits because their immigration status does not meet the current definition of lawful presence required to enroll in Medicaid and the Obamacare exchanges. Under the administration's plan, the Department of Health and Human Services is preparing a new rule to amend that definition by the end of the month. There are reports that people who receive a notice to appear in immigration court have failed to show up to court because they use the online automated website that usually is reliable. However, Department of Homeland Security has not always filed the notice to appear timely, so your hearing date and time will not appear until last minute. Currently, you need to rely on the hearing information noted in the notice to appear. Using a C is still a helpful tool to monitor after a case is filed. However, absent a new notice or order from the court, if you will be showing up to court for the first time, then you should still follow the date, time, and location information indicated on the NTA. If there is conflicting or unclear information, you should contact the clerk for that court and ask for clarification. Did you have a family member file a petition for you and you have a child aging out becoming over 21? And you are currently in the United States waiting to file for adjustment of status? Listen all the way. For many families, the new guidance will allow families to remain together in the United States in the way the CSPA intended. On February 14, 2023, USCIS issued new guidance on which chart to use. USCIS resolved an inherent inconsistency to pre-existing CSPA guidance that offered no guarantee of CSPA protection for certain adjustment applicants seeking eligibility as a child for immigration purposes. Guidance on when an immigrant visa number becomes available for the purpose of calculating a non-citizen's age in certain situations under the Child Status Protection Act. Under the February 2023 guidance, USCIS will consider a visa available for purposes of CSPA age calculations at the same time USCIS considers a visa available for accepting and processing the AUS application. As an example, when USCIS determines there are more immigrant visas available for a fiscal year than there are known applicants for such visas, and USCIS announces that prospective applicants may use the dates for filing chart when filing adjustment of status applications, then USCIS would also use the dates for filing chart when calculating the applicant's CSPA age. Furthermore, when USCIS announces that a prospective applicant must use the final action dates chart when filing the adjustment of status application, then USCIS would use the final action dates chart when calculating the applicant's CSPA age. By extension, the one-year period during which a non-citizen must seek to acquire lawful permanent residence for CSPA starts when a visa becomes available for accepting and processing a potential adjustment of status application.
Friends, show us some love and smash the like button. It doesn't cost you anything. If you have an immigration problem or need a second opinion because you cannot get a hold of your own lawyer, schedule a meeting with our team. Share information with our CARES team and they will help you get scheduled with our legal team. Now here's a secret code to unlock the free 15 minutes.